which a member has sought leave to ask without notice infringes any of the conditions set out in this rule, the Speaker may direct that it be printed or asked with such alterations as the Speaker shall direct, or that it be returned to the member concerned as being inadmissible.
Thank you.
Chair. Madam Chair.
Chair, to Honorable Seungu and Honorable Namboze. Number one, you cannot access the floor unless with the leave of the Speaker. Number two, if you looked at C gives the Speaker the discretionary right to judge your matter, whether it's of urgent importance or not. And in case it doesn't, C says the Speaker will ask you to resume your seat. So all they are arguing for is being taken care of in the amendment.
Doctor?
Thank you very much.
Chair, we are trying to help the presiding officer determine what criteria does she use to determine
she or he
to determine that this is a matter of genuine emergency, immediate and urgent consideration to warrant this. So we are helping he or she to take a decision in accordance with the rules.
Madam Chair, I was given the floor. Honorable Seungu, please resume your seat. I was given the floor. Thank you very much, Chair. My concern on this rule is about the mode of communication to the presiding officer about this matter of urgent public importance. You may, some people could be abroad or unable to be within the precincts of the Parliament, yet a matter of urgent public importance has occurred. Would we admit that a telephone call or an SMS or a WhatsApp communication to the presiding officer about such a matter would also suffice? Because you may not be physically present within the precincts of Parliament in order to bring this matter to the attention of the presiding officer.
Honorable Baigalo Lume, Doctor, that is administrative, real administrative. In most cases you've called, you have this problem. And we handle, we put it on the order paper, and I mean we discuss it, we bring it as a communication. So that is administrative. Yes, Jessica, Manuel.
Thank you so much, Honorable Chair, for the opportunity. My concern is on 1B. Let me read it verbatim. Has stimulated public concern or interest. Honorable Chair and members, I believe that is catered for under A, because if it is an emergency calling for an urgent action, probably B will have been catered for in A, because if it is not of emergency, then it will not be considered. So I feel B is redundant. Thank you.
Chair, something may be urgent but not of public importance. So B is very relevant.
I was going to give an example, but I'm restrained to give an example. I
Chair.
put a question that Rule 54.
Chair.
Before you put that question.
Okay, Manuel.
Thank you, Chair. I want to come back to the point my colleague, Honorable Seungu, stated. I think the point is, let the determination by the presiding officer be done from his or her office, so that when the same issue is now being raised here, instead of embarrassing somebody by saying sit down when actually the person is raising something that the presiding officer has already accepted from the office, let the embarrassment not come on the floor. Let it be determined from there, and if somebody is being allowed to present from the floor, then let it flow, unless this person is now presenting something else. That is the point I wanted to bring here.
Chair, 1A, a member who desires to raise a matter of urgent public importance shall with the leave
of the speaker.
So whether it is done in the office, on phone call, or where, you find your way of seeking leave.
Honorable members, I put a question that Rule 54 be amended as proposed, and further amendment by Honorable Mujira. Those in favor say and the contrary nay. The ayes have it.
Rule 59.
59.
Madam Chair, the committee proposes that Rule 59 is amended in Sub-Rule 1, paragraph M, by substituting for the word question the word point. Justification: this is a consequential amendment intended to align the rule with Rule 78 that provides for point of privilege.
Aisha,
No objection.
I put a question that Rule 59 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Rule 60.
60.
Right Honourable Chair, Rule 60, we do propose to amend by inserting immediately after Sub-Rule 1 the following. The motion or amendment under Sub-Rule 1 shall be seconded by at least 2 members, and the Speaker shall mention the name or constituency of each seconder. Justification: to ensure that the names of members that second the motion are put on record.
Aisha,
I agree.
I put a question that Rule 60 be amended as proposed. Those in favor say and the contrary. Eh? No, I haven't put a...
I agree with the amendment. I just seek clarification. What if more than one member stand?
At least, you know, in the case of, there was a case we had here, you know, on Tojikwatako, where members stood up and they said it was seconded. But in that secondment, there was no mention of names. But at least mention 2 names, then you can mention the rest, and then you can say it is seconded. So I think they are trying to cure what the court raised at that time. I put a question that Rule 60 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Rule 61.
Thank you very much, Right Honourable
61.
Chair. Rule 61, we do propose an amendment in Sub-Rule 3 by substituting for the word shall the word may. Justification: to make the requirement for remover to put an amendment in writing discretionary.
Aisha,
I agree.
I put a question that Rule 61 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Rule 64.
I wasn't on the record. Madam Chair, Rule 64 is amended in Sub-Rule 4, paragraph E, by substituting for the word
Question to the
by
word
the
point.
word question, the word point. This is a consequential amendment intended to align the rule with Rule 78 that provides for a point of privilege.
Aisha,
No objection.
I put a question that Rule 64 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Rule 70.
Madam Chair, Rule 70, we do propose this amendment by substituting for Sub-Rule 11 the following. A member shall not speak for more than 5 minutes in a debate or on any matter before the House, by inserting immediately after sub-rule 11 the following. Notwithstanding sub-rule 11, the Speaker may, at the commencement of or any time during the proceedings of the House, announce the time limit he or she is to allow each member contributing to a debate on any matter before the House, and may direct a member who has spoken for the period given to take his or her seat. Justification: to expressly provide for a time limit for the debate, and then the discretion of the presiding officer.
Yes, Christine, then AG.
Yes, Chair. I'm requesting that then we provide for also the minimum time, if we have provided for the maximum of 5 minutes. Here. And I'm proposing 2 minutes.
Chair. Right Honourable Speaker, the proposed amendment may be welcome, but it puts a cap. It restricts the Speaker. Assuming I was making a submission and I'm cut off by time, the Speaker is not at liberty to give me extra time. Yes.
The Speaker.
Yes.
No, the Speaker has the time.
No, the rule has taken away that. Which I think is not right.
That is where?
Rule 70.
Sub-rule 11. A member shall not speak for more than 5 minutes in a debate in any matter before the House. You get it, eh?
Speaker.
Just a minute. By inserting immediately after sub-rule 11 the following, notwithstanding sub-rule 11, the Speaker may, at the commencement of or any time during the proceedings of the House, announce the time limit he or she is allowed to speak. He or she is allow each member contributing the debate on the matter before the House, and may direct the member who has spoken for a period given to take his seat or her seat.
Right Honourable Speaker, it means the presiding officer's authority is limited to the time given. You cannot give extra time in the event of need.
No. Why don't I explain first? Because you seem like you're misconstruing the amendment proposed. No, I need the attention.
Abdo?
You see, we are getting a standard time of speech, and that's 5 minutes, such that every member of parliament knows that when I'm going to the floor, my time is 5 minutes maximum. However, the sub-rule, the second sub-rule, the rider, is, first of all, he's saying, notwithstanding sub-rule 11 of 5 minutes, meaning it is making sub-rule 2, sorry, sub-rule 1 inferior. The one of what? Of 5 minutes. It is being made inferior to the circumstances and the Speaker's discretion.
Honorable.
And it says, now let me explain.
Honorable Betty, please sit and. Oh, yeah.
But sometimes it's better we listen to each other such that we understand the basis, then you can make the interjections. And it says, notwithstanding sub-rule 11, meaning the rule which is providing for the 5 minutes, the Speaker may, at the commencement of or any time during the proceeding of the House, announce the time limit he or she is to allow each member contributing.
Honorable Katuntu, in the original rules, 11 already caters for both. Why are you introducing 12?
Thank you, Chair. I'm seeking, I need my senior colleague Katuntu to understand me. The first amendment requires the Speaker to set the time limit of 5 minutes. That we have agreed upon. The second amendment envisages a time, let's say, like we were having yearly elections, and the place was flooded. Then the Speaker...
AG, we have not yet agreed upon because I have not put a question.
Yes, that's why I'm debating.
You're saying that it has been agreed upon.
No.
We have not yet
myself,
agreed. Okay.
Yes, I'm agreeable on the first amendment of 5 minutes. The second amendment, that you find when the Parliament is full to the brim, and 5 minutes are not practicable, okay? So this rule says, notwithstanding the proviso for 5 minutes, the Speaker may make adjustments and say today it will be 2 minutes, okay? But I'm envisaging a time when, Honorable Katuntu, you are submitting and you run out of your 5 minutes, but what you are submitting is essential to us all and it would be important for you to go on and conclude. Yes. This amendment takes away the power of the Speaker to say, Kafuzi, you can continue for 2 more minutes.
Honorable Chair, with due respect, I told you not to touch the powers of a Speaker. So that rule is not going to be amended. Next rule.
Chair.
Next rule.
Chair.
Next. I put a question.
Can I make a submission?
Hajat, just hold on.
May I make a submission on that?
Hold
Chair?
on, Hajat.
Chair, before your question, if you may allow me, the rationale behind this amendment was to cure, maybe we didn't put it right, but the House can now adopt otherwise. The rationale was to cure the problem of a 1 minute, 2 minute talk where you are cut off before you have even explained exhaustively what needs to be understood. That was the intention. The intention wasn't to limit the Speaker or to give an upper ceiling.
Honorable members, let me put a question. Let me put a question. First of all, it is at the discretion of the Speaker. You always get, when we are starting a debate, I tell my team 2 minutes. 2 minutes. I cannot stop a lob when he has something very important to present and I give him 2 minutes. I cannot stop this side when the Prime Minister is presenting and I give her 5 minutes. Meaning, you're trying to tie the hands of the Speaker. I put a question that Rule 70 be amended as proposed. Doesn't fail, say, and the contrary, nay. The nays have it.
Rule 72. Rule 72.
72.
Yeah, I'm going to Rule 72, but at the appropriate time, I'll have that provision recommitted.
72. 72.
Rule 72
what did
is
you want to debate upon?
Rule 72 is amended by substituting or sub-rule to the
you
following.
First listen to him, then you bring up. Yes.
The conduct of the Speaker, members, the Chief Justice and judges of the course of judicature shall not be raised except upon a substantive motion. By inserting immediately after...
Honorable Chair, why can't you say members of Parliament?
Members have been defined already
Okay,
to
okay,
be members of parliament.
okay.
By substitute for the following: the conduct of the speaker, members, the chief justice, and judges of the course of judicature shall not be raised except upon a substantive motion. By inserting immediately after sub-rule 2 the following: a member shall not impute improper motive to the president or the name of the president to influence debate. It is out of order to make reference to the conduct of the president, speaker, members, chief justice, judges of the courts of judicature in an amendment question to a member or remarks in a debate on a motion dealing with any other subject. It is out of order to impute improper motive to the president or use the name of the president to influence debate. And this is the justification: to have the provision clear and concise, to bar imputation of improper motive on the president and use of the president's name to influence debate. I need to emphasize that this first part of the categories of people or offices is already in our rules. That one is concerning the speaker, members, chief justice, and judges of judicature. What we've added is that of the president, because the others are already provided for in the current rules. I beg to move.
Thank you, Chair. Yes, Bugabula.
Thank you, Right Honourable Speaker. Madam Chair. Madam Chair, the Chair has said the issue of judges and so on is already provided for. We had the issue of the Speaker and the Chief Justice. By now, the issue of judges, Right Honourable Madam Chair, is going to cause issues here that we can't talk about them before we come to seek permission from your office. There are situations and cases where you don't need to first come. I have to raise an issue when there is something that is not right with the judge. But now, the chair has brought in a situation that the judges have also now become big issues in this house that we can't talk about them.
Honorable Bugabula, first of all, you know very well in our rules, you cannot discuss about a person who is not in this house. So how will you talk about them? You shouldn't. Yes, Chair. I'm Aisha.
Chair, I lost argument because all the other officers were exempted by law except the president. And the issue is that if other people need a motion, why not the president? So I did not depart from the majority report.
I put a question that Rule 72.
Honourable Speaker, I'm a bit constrained by this, because sometimes the head of state could be at functions, issues directives, as an example, which directives are meant to be implemented, acted upon. And as Parliament, we could seek clarity from the Minister for Presidency, for example, who I see here. It's good to see you, Honourable Minister. I don't think that's a bad thing, because you see here we are saying it is out of order to impute improper motive to the president or use the name of the president to influence debate. When I ask for clarity about a directive, one would say I am influencing debate. That's not a bad thing, because ultimately, Right Honourable Speaker, usage of whether it be language or improper motive about anybody, by the way, the buck stops with you to call a member to order. But now I see when we put this within our rules to say we cannot even use the name of the president to influence debate, debate is not a bad thing. Because debate would be clarifying something, would be seeking, because you see the president is represented here by the executive, beginning with the vice president, who is rarely here, the prime minister, the leader of government business. I think it's okay to at times say the head of state said this, or maybe a policy direction. Could you clarify? Now, if we pass this, then I'm not even allowed to raise that issue. But ultimately, if any of us in this house raises anything against anyone, whether it be in this house or outside of this house, that is outside the law, that is improper. Right Honorable Speaker, you have got the prerogative. The rules allow you to call someone to order. So I think we should not limit this.
And what do you mean by the word? What do you mean by the word to influence?
You know, when you say Rule 72, contents of a speech, 72.2, the conduct of a speaker, members, the Chief Justice, and judges of the courts of judicature shall not be raised. Shall not be raised, except under a substantive motion, and in any amendment, questions to members or remarks in a debate on a motion dealing with any other subject, any reference and conduct of persons mentioned is out of order. Now, all other heads are catered for. The first to be catered for should be the president. The first to be catered for is the president. Yes. Yes, Haj.
What is the current situation as the rules are now? Let us read the rules as they are. 1. Rule 72, sub-rule 2. The conduct, and listen this, the conduct of the Speaker, members, the Chief Justice, and judges of the courts of judicature shall not be raised except upon a substantive motion. So there are two operating words here. One, what is being bad here is conduct. Conduct. Then two, there is a proviso that actually the conduct can be raised, but only on a substantive motion. That's what the rules provide. So it is not that we are barring completely discussion of the conduct of these officers. And what we are doing additionally, right, Chair, is to add on the office of the Fountain of Honor on this. Okay, can we also have proper conduct also? So this is what it is. Now, so the issue is not that the rules are barring the discussion of the conduct, but it can only come on a substantive motion.
AG.
Right Honourable Speaker. Right Honourable Speaker, with all due respect to my senior colleague, if you read the first proposal for amendment, it says the conduct of the Speaker, members of Parliament, conduct of the Speaker, members, the Chief Justice, and judges of judges of the courts of judicature shall not be raised, blah, blah, blah.
Except
I want to propose that in this very lineup, we add the president.
Yes, that's okay.
Then it will have catered for all the rest.
That what the learned attorney general is proposing, that the rule states that it is only to add on the office of the president.
Yes.
Is that your proposal?
Yes.
Would my minority member have an objection? Would you have an objection? The majority and the minority have no objection to that.
Thank you, right. Thank you, Madam Chair. Madam Chair, I'm seeking clarification from the chair of the committee whether he has given a provision that in a situation where we have to present a substantive motion against the conduct of any other person, including the speaker, and the speaker doesn't honor the motion, where do I run to?
You can go to court.
Chair.
Honorable members. Honorable members. Honorable members, I put a question that Rule 70 to be amended as proposed by the Deputy Attorney General. Those in favor, by the committee and amended by the Attorney General. Those in favor say, on the contrary, nay. The ayes have it. Now get out.
Rule 73.
Rule 73, the committee proposes that it is amended in sub-rule 2.
There is a procedure matter from Bukunja.
Yeah. Madam Chair.
You first cool down. Now you're smiling. You can talk.
Madam Chair, I thought that since we are amending these rules and they take some time, we needed to reflect a lot on some of those issues that we want these rules to cure. And I wanted to bring to your attention something that had taken me to the Rules Committee, and I am mentioned as one of the people who had a dean memoranda, and I had discussed with the chair on how to bring this matter to your attention. The matter concerns the acceptance of people, members to speak, to access, to have your attention in speaking. Because this is a democratic space where majorities and minorities are present. And I had a feeling that I needed to have an amendment to the rules to ensure that all shades of opinion in this parliament be heard on a subject matter under debate, so that it is the speaker ensures purposely. I wanted to get the attention of the speaker. Yes, on Rule 70. That is why I wanted to raise this procedural matter on Rule 70, which we are surpassing. Yet I had recommended a Part C, that subject to sub-rule B above, the Speaker shall ensure that the position of all shades of opinion represented in Parliament as are heard on any subject matter under debate. Justification was that Parliament is a democratic space in which the majority and minority coexist and in which all positions need to be heard. That's what I wanted to bring to your attention, Madam Chairperson.
Chair, indeed the member was entertained the committee and his opinion was heard and considered, but the committee was of the view that once we're in Parliament, we cease to look at ourselves as people coming from our respective parties but we have the people in government and the people in opposition. The proposal of the colleague is that the speaker would call, can we hear from DP? Can we hear from FDC? Can we from, that's his proposal. But we thought that once we are here, we would hear from opposition and the ruling party.
Honorable members, Rule 70, time and manner of speaking. A member desiring to speak shall, in the case of a member physically present in the chamber, raise and face the chair of the speaker, or in the case of a member virtually present in the house, raise his hand or her hands up, and shall not speak until he or she catches the eyes of the speaker. Now, honorable members, you want me to start saying, no, we have shades of opinion. Shades of opinion, there is opposition, ruling party, PWDs, military, independent, youth, elderly, women, honor. And if they have not stood up to catch my eye, you get it, eh? Is there any time that we don't pick a person and we remain without nobody talking? There's no time that we don't. Maybe let's hear from the chairman where he didn't make. No, just a minute.
Thank you, Chair. Honorable Chair, we address our mind to the proposal by the Honorable Dr. Lulu. Unfortunately, we couldn't agree with him. There are only two sides reflected, either in the Constitution or in the Administration of Parliamentary Act or even in our rules. That is both sides of the House. No, you see, the thing called independent, we should also, every independent here, I am one, but I'm independent from another independent person. We are not in any lump together, only that we came on individual merit. So the only two sides. So we didn't appreciate the point raised by the Honor. Like, I think these rules sufficiently cover everybody interested, and there is no mischief intended to be cured by that proposal.
Madam Chair.
I said you don't access a microphone if I give it to you. Can we first go to the next rule?
Rule 73.
Did we put the question? Okay, ma. Did you put the question?
Yes, I did on AG.
Rule 73. Right, Honorable Chair, it's the proposal of the committee that Rule 73 is amended in sub-rules 2 and 5 by inserting the phrase of chairperson of a committee immediately after the word speaker. Justification. To empower chairpersons of the committees to determine matters of sub judice that arises in their respective committees. Because when a matter is sub judice and there is a presiding chairperson, he should be able to determine it, not to adjourn the committee, then you run to the office of the speaker, or you write the speaker until you get a reply. And there is also another process in case somebody is dissatisfied with the decision of the chair.
Because the chair has delegated powers, and the chairman should actually not wait for the speaker to determine whether it is sub judice. So you should be able to act other than saying, let me wait for the speaker. AG, is that okay with you? Aisha, you okay?
I agree.
There was consensus.
I put a question that Rule 73 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Rule 78.
Madam Chair, Rule 78 is substituted for the following: interruption of debate. 1. Debate may be interrupted. 1A. by a member of privilege suddenly arising, by a point of order,
By a matter of
by a
privilege.
matter of privilege suddenly arising, by a point of order being raised, upon a point of information, elucidation, or clarification, and D, upon a point of procedure. When giving leave to interrupt the debate, the Speaker shall follow the following precedents: points of privilege, points of procedure, points of order, points of information, elucidation, or clarification. A member who stands up to interrupt the debate on a point of privilege, procedure, order, information, elucidation, or clarification shall not depart from that point.
And you should also mention the rule.
I'm continuing. Insertion of new rules. The rules.
Let's finish this one first.
No, it is just coming at the end because this one is it all concerns rule.
No, that's
78.
a new rule. That's a new rule.
Okay. It's all concerns rule 78. So I want to go through first the whole of it. Yeah, but we are particularizing it.
That's 78A.
To appreciate it, you need for me to complete. That's when, because members are going to jump on this without knowing what is amended.
We shall put 2 questions on 78 and then on the new rule.
Okay. And there's a reason why. You see, Right Honourable Speaker, if we pass this one and the House has a problem with the subsequent one, when you've already passed this, what happens?
Okay, okay. You read, then we shall
Because
put
you
2
have
questions.
already passed it. I was just trying
You go through, then we shall put 2 questions.
Yeah. Thank you very much, Right Honourable Speaker. Insertion of new rules. The rules are amended by inserting immediately after Rule 78 the following. A matter may arise, that's 78A1, A is capital. A member may raise a point of privilege during debate where a breach of privilege suddenly arises. 2, where a member raises a point of privilege, the Speaker shall make a ruling on the point of privilege. 3, the Speaker shall, in making a ruling under Sub-Rule 2, have regard to the provisions of the Parliamentary Powers and Privileges Act. 4, notwithstanding Sub-Rule 2, the Speaker may refer the matter raised on the point of privilege to the Committee on Rules, Privileges and Discipline. 78B, point of order. A member may raise a point of order on unparliamentary language being used by another member or on any matter of unparliamentary conduct by another member immediately the unparliamentary language is used or the unparliamentary conduct arises. 2, where a member rises on a point of order, the member holding the floor shall immediately resume his or her seat. 3, where the point of order has been raised under Sub-Rule 2, no other member shall, except with the leave of the Speaker, rise until the Speaker has decided on the matter. 4, where a member interrupts debate on a point of order, the member shall cite the rule of procedure he or she deems to have been breached by a member before subjecting the member to the Speaker's ruling. 78C, point of information, elucidation, and clarification. A member may rise on a point of information, elucidation, or clarification based on a matter raised by a member holding the floor, and may only proceed with the point if the member holding the floor is unwilling to take the point of information, elucidation, or clarification and resume his or her elucidation or clarification more than 3 times. 78D, point of procedure. A member may raise a point of procedure where a breach of rules arises. And members, take a note of this because this is a fundamental departure from the current status. And I repeat, a member may raise on a point of procedure where a breach of rules arises. Where a member raises on a point of procedure, the member holding the floor shall immediately resume his or her seat. Where the point of procedure has been raised under sub-rule 2, no other member shall, except with the leave of the speaker, rise until the speaker has decided on the matter. 4. Where a member interrupts debate on a point of procedure, the member shall state the rule of procedure he or she deems to have been breached by the member holding the floor, or on the procedural matter he or she wishes to be ruled upon, before the presiding officer makes a ruling. Justification. To clarify when a point of privilege, order, procedure, and information, elucidation, or clarification may be raised. What has been happening, colleagues? Members use point of procedure really to call the presiding office. They rise up point of procedure and they go in substantive debate when there is nothing procedural at all. So we are now trying to redefine. If you are to sign up on a point of procedure, please be on a point of procedure and state the exact rule. Other than point of procedure and then you go on another tangent. That's what we are seeking to clarify, Madam Chair.
Madam Speaker, you know we are discussing and we are amending.
Honourable members, you've heard Rule
Madam Speaker.
78.
Madam Speaker.
Yes, Alex. Yes.
Madam Speaker, we are just making the rules, honourable colleagues.
But
Madam Speaker, the way I see we running, leadership is politics. And leadership being politics, to be limited and tied not to talk by quoting every rule that every person should say, it is really trying to jeopardize.
I thought that is one of the documents that is given to you when you're being sworn in. So you ought to be knowledgeable of what role you're standing to debate
Right,
upon.
Madam Speaker, but the way the committee is bringing it is really tying our hands so that we don't have freedom of speech in the House.
You know, we need discipline in the House, decorum. Yes, Alex. Alex, then Doug.
Right Honourable Speaker, Chair and colleagues, I am constrained also almost to go along what a colleague was talking about. You know, in legislation, colleagues, some lacunas are deliberate. It's a principle in legislation. Once you make the law, and this law is too stiff, the chances of breaking that law are very many. That's why they insist on having a malleable law, malleability, malleable, soft, so that the speaker has a latitude to make a ruling, so that even a member feels free to make a contribution. And I think that's what I think we should be looking at. Let's not make very difficult and stiff regulations that might be misconstrued to gag members' freedom to debate.
AG?
Madam Chair, stringent as these rules may appear, the Speaker, the presiding officer, is still at liberty to say you can speak, because she's the custodian of the rules. But these rules are placed there so that we do not abuse the process. But, Right Honourable Speaker, while I agree with the proposals, there is only one that I wish to raise a concern on. 78C2. The proposal in 78C2. It says where a minister is holding the floor and a point of information, elucidation, clarification is raised, the member shall not reject the point of information, elucidation, the minister shall not reject the point of information, elucidation, clarification more than 3 times. Now, that may be okay. My worry is...
Maybe you could put in succession.
Pardon?
In succession.
Yeah,
Successive.
Okay, 3 successive times.
Yes.
Yes, but you see, my fear in this, Right Honourable Speaker, even if you put the word successive to correct it, members can deliberately decide that this minister will not speak. Yes, because if I start, Right Honourable Speaker, Right Honourable Speaker, I need your attention on this.
Yes.
Members can conspire and say, we will not hear him out. When you speak, Naruyima says information, Lope says, I'm giving an example, elucidation, and you cannot say, so you sit down. After that, you get back, they will raise it again. Okay? So, Right Honourable Speaker, I want us to be cautious. This rule, it may fail a minister from presenting whatever intends to present.
Honourable
Chair.
Yes, Honourable
Thank
Aisha,
you.
then
Thank
Honourable
you.
Minister.
Thank you, Honourable Chair. Number one, to honourable colleagues, these provisions are actually giving us opportunity to interrupt debate, so they are not very stringent. The point that the Attorney General is very worried about is actually to help Parliament, because the practice of some ministers has been that they will come to read statement, you ask for clarification, one will keep quiet as if he's not hearing, he will read the statement to the end and sit down. There are circumstances where members of Parliament need to be clarified on the information that the minister is giving. So that's why the provision here is saying, yes, you can decline to accept 1, 2, 3, but at least after 3, have sought, and 3 from different members, not the same member Aisha standing and say, information. If you've declined at least 3, give way for people to ask for information and clarification. It's a good thing for Parliament to be informed of what the executive is doing.
Just
Thank
hold on.
you.
Hold on.
Thank you, Right Honourable Speaker. I want to support the position of the committee on that entire. First of all, this House, we have seen that members abuse all these points of order, procedure. Someone says procedure and they're talking about the goats somewhere. And I think the amendments are curing that. People say point of order and they go on to debate. This is curing that. Right Honourable Speaker, we all swear by these rules when we come here. There's nothing stringent about the amendments. We need to keep our house in order. Sometimes this house looks like a marketplace because people are saying order, procedure, and it has nothing to do with procedure. So, Right Honourable Speaker, I support that we have stringent because you are the custodian of the rules. If you think that I need more time to speak about something, you will allow me or another member to speak. But we can't want to water down the very rules that we swear upon when we come to this Parliament. I thank you, Madam Speaker.
Honourable members, we are talking about an orderly house, which will be productive. And that's why we are bringing these rules. And I want to make a clarification on Rule 72.2. Some people are thinking that we are infringing on the immunity, the privileges and immunity of the president. That is not correct under the Constitution. That is not correct. The precondition for the substantive motion is to ensure that there is compliance with the Constitution and any other laws of the land. We only are saying that the president should not be discussed about unless you bring a substantive motion. Honorable Kibal, have you heard? Okay.
Madam,
yes, Honorable
Madam Chair.
Minister. Honorable Minister, then.
Well, first of all,
come and sit here.
Madam Speaker, I would like to thank you and colleagues, Madam Chair and all colleagues. I want also to try to speak to 78.2. Honorable colleagues, at one time you will be where we are, and at one time we might be where you are. So I want first to say this. When we come here on behalf of government, specifically to address a subject matter which in my considered opinion has been directed by this August House with the rich knowledge of information. There's a reason why I'm bringing this context. Number two, it is also true that sometimes you would like to seek for information, clarification from my presentation. I want to implore us, like the Deputy Attorney General did say, it is also true sometimes you can afford and you can afford to deliberately deny me space to address you. So I want to say this, that the question of information, first I want to go back to the main principle. What's wrong with the current existing rule of procedure which we have been having?
Honorable members.
Because it should be
Honorable members,
at my discretion.
Honorable members, let the minister finish.
It should be at the discretion of a member holding the floor.
Of the speaker.
Of the speaker holding the floor to ask.
No, the speaker.
Okay, the speaker,
Let
the chair,
yes.
and the member holding the floor to give you permission, to give in information, clarification, where applicable. But for us now to begin saying we have 3 times, Honorable Chivumbi is my good friend and many others there. They can afford deliberate to say the subject matter of Ogwang is coming to present on behalf of the Minister of Education, in my considered opinion, should not be listened to, entertained, and you can afford to frustrate it. So, Madam Speaker and Madam Chair, I really want to beg the August House that please, we come here for a purpose on behalf of government to give government business. I want to plead with you, let's maintain the existing rule as it is. I thank you.
Honorable members, what was in contention was on the issue of the minister. 3 times. You get it, eh? On 3 times. What, a minister on clarification, elucidation, consequent 3 times, the consecutive 3 times, the minister should be able to allow a clarification. Why don't you leave that to discretion of the speaker? Yes, leave it to the leave that to the discretion of the speaker. Why are you, honorable members? Why are you over reducing the powers of the speaker?
Right, Honorable Chair. Right, Honorable Chair. The current situation, can I be heard? The current situation is that it is the discretion of the minister holding floor. And what they have done, they have consistent, some, not all of them,
In most cases, you've seen the speaker saying, Minister, please clarify. Clarify, take the information. In most cases. Yes. I remove that part. Dagger. Edit. I mean, reframe.
Right Honorable, we are proposing to say this proviso notwithstanding, okay, the minister shall, okay, I may not word it properly, but the minister shall be required to yield once.
But you people, is there somebody chairing this house? Is there somebody chairing this house?
Yes.
The speaker is chairing this house.
Yes.
Yes.
So, Chair.
Even if somebody rose up on a point of information, it is a speaker to allow. So why are you pushing the whole burden to the minister? Daudi, you want to say something? Honorable Minister. Internal Affairs.
Okay.
Right, Honorable Speaker, I wanted to move in unison so that we avoid an orchestrated or deliberate effort to frustrate a minister. What if the 3 times is repeated? Should we now rest in the solace of the speaker intervening? Or we need some express provision, a proviso of sorts to say, provided the repeated interruptions don't go beyond a certain point, maybe something like that.
Madam Chair. Madam Chair. Madam Chair.
Yes.
Chair, you know, rules are there to help us get away from reliance of the presiding officer's mood. Sometimes the presiding officer's mood could be that the person should not give way. I pray, Chair, and I beg your indulgence that you don't misunderstand me. I pray that you allow us have a role that will protect members from reliance on the speaker's mood, so that we have a role for the ministers to give way, to give us information, because the information is very necessary.
Honorable Aisha, the speaker's role here is to protect all members and ensure that there is harmony and orderly in the house. Yes, and when we are doing that, we are doing it for the good of Ugandans out there. Yes.
Right Honorable Speaker, every time we are making a law, including our own rules, it's because there is a mischief we are intending to cure.
What are we curing now?
Now here, in cases where a minister has refused to yield, the speaker has already said, please yield. So what is the mischief that we are trying to cure?
Can I answer that? Madam Chair, the minister is holding an office in trust. It's not about him as an individual. So when a member is seeking clarification, the speaker doesn't know what clarification. It's the member who knows the clarification.
Who gives the member permission to speak?
The presiding officer does, but not until you have put the clarification. You only stand up and say clarification. And that's the only judgment you have to use. But the substance of the clarification is the member raising it, who knows? So if you just stop him without you as a presiding officer even knowing, that's what they put you in a difficult position. Because, Right Honorable Speaker, let me make my point. Right Honorable Speaker, this has nothing to do with the presiding officer's powers. Why? When a member stands up on a point of clarification, he does not go ahead until the speaker has given him the audience. You will not hear the clarification, you as a minister, until it has been put on the floor. But if you consistently say no, no, and somebody is seeking clarification, because they are not asking about the Honorable Kafos, they are talking about clarification from the Attorney General.
Honorable members, I don't see anything we are chewing. In the circumstance that a rule is not provided for, we shall apply Rule 8. So can we have that part of
Thank you, Madam Chair.
Hassan, after
thank
that,
you,
Hassan.
Madam Chair. I think whatever we're discussing about, anything touching the powers of the Speaker should be disregarded. Yes. Madam Chair?
Yes, I'm listening.
Any discussion regarding the powers of the Speaker should be disregarded, because the Speaker must maintain the power he or she holds. No. I'm being honest. Because we shall not cure anything.
I have not given you to talk. Chair, I have not given you to talk. Sit.
Thank you, Right Honorable.
Thank you. Haji.
Thank you, Chair.
Honorable members, let's listen. Not Haji Noah, but Haji Hassan.
Madam Chair, the fact that the front bench is worried about the insertion of that particular rule is problematic in itself. Points of clarification and elucidations rise because members want the minister to clarify on that particular matter. Now, deleting it and shying away from it means that we are leaving the members out of debate that is happening at that particular time in the House. Madam Chair, we know we legislate for our people, and rules are rules. We have to respect rules, else we are savages. So my application on that rule, Madam Chair, is to allow the Chair proceed with the rule the way it is, because it's going to allow the members to come in that particular debate. Thank you, Madam Chair.
Thank you, Madam Chair. We've been making rules in good faith. Ever since we started amending rules, we've been amending them in good faith. But when you look at this sub-rule, the ministers are saying, no, let's remove it. The other side are saying, let it remain. Why don't we delete this so that we keep what we have been using as Parliament? Because we have to amend these rules in good faith so that we maintain the good faith. Thank you.
Yes, Itungo, then Moses. Honorable members, if you raise up and then Santa, from order, how can you two men come in front of the Speaker?
Madam Chair, the Chair is in the meeting, but okay, I want to bring to your attention Rule 70, which you have just read, and specifically the last paragraph. The last paragraph we are saying that a member shall not speak until he or she catches the Speaker's eye. Now, if the rule is already there, why do you want a person to raise a point of information or procedure without the eye of the speaker? So, no.
Can I give information?
Chair, you need different views on this.
Moses.
He has
Madam Chair, looking at that law, for me, I think I would not have a problem. But where the problem arises is the 3 times. My question now, 3 times by who? By an individual member who is standing to ask for clarification, or for members? Or the 3 members?
3 times. 3 times, yes.
Thank you, Right Honorable Speaker. I wanted to seek clarification again, maybe from the Attorney General or the Chair, because what if members conspire, like 10 of them or 20, from either side, opposition or NRM side, and they are deliberately doing that to fail a minister? Because the rules here dictate that maybe, unless the speaker is not allowed, but after the minister's presentation, members will debate. What if something that you have not, the minister has not brought out well, you note it down and you bring it out in the debate? Without because many members are going to conspire here, order 20 of them, and you fail the minister. Can't we do
Madam
that
Chair.
in a debate?
Thank you.
Madam Chair.
Honorable Mpuga.
Macho Black, Right Honorable Chair. Honorable Chair, we first of all take exception to the submission of the Honorable Ngopek, who was trying to incite the Speaker by way of his submission, that the Speaker can reject members' submission on this subject matter. But that said, tongue in cheek, we are trying to do 2 things, Right Honorable Speaker, with this amendment. One is to May I proceed, Right Honorable Speaker and Chair? Thank you. I was trying to say that we are trying to deal with 2 principal issues here. One, access to the microphone and the power of legislation. 2, the doctrine of separation of powers. This is a space for members to legislate and represent their constituencies. And for the ministers, it's space for accountability. And therefore, the amendment, if I understood the chairperson well and the committee's intentions, is to try and cement the power of members to demand for accountability from ministers, and therefore there should be no denial. We have been here, and ministers are denying clarification, and then they take leave and even take flight. Chair. And when that happens, you constrain the whole intention of legislation and representation. The Speaker, under the rules, will be at latitude to even say, I have ordered that this matter takes leave. That power cannot be taken away from the Speaker by this rule. That's why I took exception to the submission of the Honorable Ngopek, who was trying to incite you, as if this rule has eyes.
Nobody has incited me.
Of course, I saw him as the Speaker, but of course you were smart to.
Nobody has incited me, but I'm also telling you, much as even if you stand 10 times, but if the Speaker has not given you time to speak, will you speak?
Exactly, that's why.
But at the same time, if somebody is standing up on a point on clarification, I have seen so many times ministers not wanting clarification, but the presiding officer says, clarify, take it, give way. Why are you abusing that?
So, Chair, it's just because the presiding officer does that discretionally because doesn't know the matter of clarification from the member at the time the member rises.
We've never asked for what clarification. All we want is let the member seek for a clarification.
That's my point, Right Honorable Speaker,
Okay,
and I think
okay.
they are getting away with not accounting for their actions.
Okay.
Yeah, thank you so much. Yeah, thank you
Nene
so much.
Gwalu.
Thank you so much, Right Honorable Chair. Madam Chair, you are the custodian of the rules that we are making. And here is a problem that sometimes members want clarifications from the ministers. And sometimes it's very important matters that needs clarification even on the ground. But the minister might deliberately fail. So, Madam Chair, being the custodian of the rules that we are making, I think this is a very simple matter. Any point of interruptions must go through the speaker. And you know the interest of your members that they want clarification. So if it's through the speaker, I see no way how a minister can consistently and repeatedly refuse to deny the point of interruption, Madam Chair. Thank you.
Yes. Yes.
Madam Speaker, we have seen situations here in this House where members have sought clarification only once, and you have allowed a member to ask the minister, and ministers have given way. Of course, we also have ministers who fear to respond to questions from members. But with your discretionary powers, we have seen situations where you have allowed members here to raise their matters to the ministers. Just like point of procedure, just like order, it is at the discretion of the speaker. So my humble view is that the way it is, and members also, the ministers, should be able to give way. Why do you fear to respond to our clarifications? Thank you very much.
Madam Chair. Madam Chair. Madam Chair, with your leave, we've just observed that we are still having problems of the Electoral Commission because when the minister was here to present, we asked for clarification and the minister did not grant us that option to clarify on those matters. So up to this day, the problem still exists. We haven't got solutions, whereas the minister came and presented a statement, then later on he left. So when we want clarification...
Honor, I have not even heard one word you say.
Apologies.
So can I have Doug?
Right Honorable Speaker, considering the many different views we have on this, and for avoidance of clogging the system going forward, I move that the proposed amendment under Rule 78C2 be deleted.
Chair.
Right Honorable Chair, I'm going to respond to the request of the Attorney General. But before I do that, I have to say this. Sometimes the reason why people have been jumping, or colleagues have been raising point of procedure, whereas they are not point of procedure, or even order when it is not, is because they have failed to get the clarification. So they move, they move around, and they say procedure. Moreover, it is not procedure at all. But having said that, I hope the executive has picked the lesson that members want the clarification. And if you continue behaving the way you are, we shall bring the amendment again. As of now, for peace, let us consider that particularly. But if you do continue behaving like it has been, we shall be back with that amendment. I concede right or no.
Thank you. Honorable members, I put a question that Rule 78, with its attendant amendments, as proposed by the committee and modified by Doug, be approved by this honorable House. Those in favor say on the contrary nay. Let's have it.
Rule 82.
82. 82.
Right Honourable Speaker, the committee proposes the following amendment. In sub-rule 1 and A, in sub-rule 1, by inserting immediate after the word shirt, the words cravat and flaps. B, the other time I tried to explain to colleagues what cravats and flaps are. The presiding officer now is putting on a cravat. The flaps are those which they are distinct from the cravat. B, by deleting sub-rule 2, 3, 4, and 5. 2, in sub-rule 1A, by substituting for sub-paragraph 2 the following: decent dress with sleeves or dress with jacket. B, by substituting for paragraph 3 the following: decent blouse with sleeves and decent skirt or decent trouser, or decent blouse with jacket and decent skirt or decent trouser. C, by deleting subparagraph 4. 3, by inserting immediately after sub-rule to the following: a member attending house or committee meeting who does not adhere to the dress code prescribed in sub-rule 1A shall be cited for being out of order, and the presiding officer shall order the member to withdraw immediately from the house or committee and return when dressed in accordance with the rules. 4, for purposes of this rule, decent means dressing in a manner that is socially acceptable and generally considered to be smart, good, reasonable, and portrays a good image of Parliament. Justification: to maintain decorum and dignity of Parliament. But I'll do some explanation on the justification. Honourable colleagues, members of Parliament should be an inspiration to the public. The way we speak and the way we dress and the way we conduct ourselves. We cannot have a house and it is like, it's like a market. People come dressed in all manner of cotton materials. And we have a problem, Right Honourable Speaker. We know the work, the very good work done, for example, by our staff, the doorkeepers. They are very, very good members of staff. But sometimes a member walks in like a doorkeeper. You don't know whether is this a doorkeeper or this is a member of Parliament. 3, colleagues, sometimes our staff are smarter than the MPs. So it is in pursuit of decorum, of respect, that we think we should not only be MPs but appear to be members of Parliament. And that's why we are proposing this. Right Honourable Speaker, you've got this thing called, is it Mandela shirts? Everybody walks in here and so without mentioning individual names, I think it is time to look in our rules such that we give that impression, that image of what a member of Parliament should be. And this is not too much to ask, honourable colleagues. For those of you who are professionals, everybody knows that, for example, the lawyers, they know how they dress in courts of law. Doctors, how they, even nurses, they dress in a particular way to, 1, distinguish them from their patients. Lastly, about the UPDF. 1, the membership of the UPDF in this House is constitutional. Nobody should think that this rule in any way touches the status of members of the UPDF in this House. That's number 1. Number 2, I've heard people say that we are banning UPDF uniform from the house. Far from the truth. No person in his sound mind can do that, because certainly it will be unconstitutional. However, just look at the member of the UPDF currently seated in this house. Extremely smart. Just look at them. They're extremely smart. And there is also another pair of uniform which they use. They have it's something like a khaki. The upper one is like a plain khaki, but it's also plain. And then they put in something green. It is sort of ceremony, I think. I don't know how they call it. But it is some khaki shirt up. Smart. And in any case, the UPD officers here should be identified sometimes by their own ranks. So they cannot come here dressed in civilian uniform. We would like them to come here, if they so wish, in their uniform. Then I can say Kano Nekesa, I can say General Mujira, because their ranks are on their shoulders and they can only be in uniform. However, we have one exception, which we are proposing, that our UPDF officer should not put combat uniform when they are in the house. They must door. Why? Because ordinarily, right on.
Continue.
If you can save
Please continue.
This house from Onongongpek. Because generally, these are supposed to be, for example, like a combat materials or uniforms, or even if they are dressed in their own camouflage, or even in their own barracks and so on, that is okay. But when you are here, like we are prescribing a dress code for members of parliament, even us, we are not allowed to come here dressed as the way we wish. But we are saying in the rules we should dress this way. So we do request that the UPDF officers dress formally, smartly, like we see them now. We have no objection. Madam Chair, I beg to move.
No, there is a minority. There is a minority.
Thank you, Chair.
Honorable, can I first ask a question before you hear the minority? Assuming somebody, say on Fridays, puts on a council and a court, is that acceptable or not?
Right, Honourable Speaker, since we released this report, we have had a number of interactions with the colleagues. And one issue that has been pertinent is about the council.
And a court.
The council. And we sort of have a consensus that on that one we are going to concede.
A council and a court.
Yes, and a court.
Yes.
And a court. On that one we are ready to concede.
Chair.
Yes.
Chair, I am Right Honourable Chair. I'm happy to hear my chairman saying he's intending to concede on that, because it was a matter before the committee and there was a bit of disagreement. So I disagree with the removal of kanzu and jacket. That one I disagree. I propose that we remove the military attire, and the argument is clear. Military attire. That is 6. That is 8216 military attire for members of the armed forces. How wish members would listen. You ask which one.
Honourable members, you listen. First listen.
So, Right Honourable Speaker, to me and to many of us do not understand the variance of those military attires. The military attire is a military attire. To us, this is a civilian space. Military attires are very intimidative. Actually, the pips my colleague is arguing for, that's important that we get to see the pips. Actually, that intimidates people more. When you hear someone is a general you may kind of subdue some people because of the pips. So my argument is, Right Honorable Chair, that military attires should not be a space for Parliament. They should come here as colleagues, dressed in their civilian wear. Important to know, Right Honorable Speaker.
Yes, members first listen to her point of dissent. We are listening to the point of dissent.
Right Honorable Speaker, we all come from different professions. You know, even lawyers have a style of wearing. They're not going to come with their clothing here as lawyers. And doctors have their style. So we recognize that we all come from different professions, and as we enter Parliament, we leave our professions out, and we enter Parliament as representatives of people. So I recommend that military attire be removed for both men and women. I recommend that we should insert on the female wear, we insert hijab as an acceptable wear for women members of Parliament, and leave on kanzu and coat.
What hijab is what you're putting on? Yes, we have not said you are removing that, Hajat.
Right Honorable Speaker, a hijab is not in our rules as of now, and a hijab is surviving.
So we are inserting
How I
a
wish the
hijab.
love master would listen. And Right Honorable Speaker, a hijab currently is surviving on allowance of traditional wear, okay? Now, when you delete traditional wear, a hijab will have no room. So unless we leave there traditional wear, or we insert hijab as unacceptable wear for
Hajat.
Muslim women in this Parliament.
Hajat, one we've accepted, we insert a council with a court. Okay? Then the hijab.
Madam Chair. Madam Chair.
Wait, order of members. I just want to make a clarification. We have a hijab for a religious aspect. We have a council with a trouser inside. Don't come without a trouser. And a coat. Yes? Wait.
Right Honorable Speaker, as you deliberate on this issue of councils, we need to specify that there should be a long trouser inside the council. Because it has happened here before. I don't want to go into detail.
Honorable members, I want to first of all commend. I want to commend the UPDF that we have in this house. I think we have the most disciplined UPDF in this house. The most disciplined. At times I even forget that they belong to UPDF. The people, the UPDF that you have here. And secondly, that uniform they are putting on is official uniform. It is not a gazetted. It is not the other Madoa. That is the one we are saying we don't want. But this one, this is like the one we put on in Chankwan's. Let me hear from General.
Right Honorable Speaker, I want to, with due respect, debunk what the Honorable Kavanda submitted, that this is for civilians and we have to put on civilian attire. We are a constituency known to the Constitution, for your information. So we have to be identified as
they are
such.
elected here as UPDF.
And the only identifier is uniform. Now the detail of what uniform is suitable for this environment is what we are talking about. I agree the camouflaged uniform is for combat. We have number one, the red tunic for the army, and then the blue for the Air Force and the other services. This one is number two.
for its work dress. So maybe if the committee agrees and Parliament agrees, we can approve number 2 for purposes of Parliament.
Thank you, thank you. Thank you, Daudi.
And we have no objection at all.
Thank you.
Thank you. Thank you.
Honorable members, I am part of the Gomez team.
Right, Madam Chair, we concede on the Gomez.
Yes. Why? Honorable
Thank
Daudi.
you. Thank you, Right Honorable Speaker. Chair, Right Honorable Speaker, I would request that
Honorable members, can we have some order?
this chair suggests that a member attending House or committee meeting who does not adhere to the dress code prescribed in Sub-Rule 1 shall be cited for being out of order. Right Honorable Speaker, I would also request that we insert in a member attending House physically and virtually, because we have seen members here on Zoom.
Honorable members, let me first say, honorable members, one time somebody was voting on Zoom and the person, I don't say.
Honorable Chair, I concede to the Honorable Kabanda's
Thank
amendment.
you. Yes, Honorable Rone. Honorable Rone.
Thank you, Madam Chair. Madam Chair, this parliament is in Africa. Madam Chair, I'm one of the people who respect African culture. Madam Chair, it will be unfair. The UPDF have been accepted. The other side has been accepted. Then you chase away the African way. I'm smart in right now. People like Macho, very smart in the African way. People like that man, very smart in the African way. So I request African wear to be accepted. Thank you so much, Madam Chair.
Let me first have a Bwalu. Okay.
Right Honorable Speaker, I wanted to inform Honorable Orone that African wear is not defined. You can even bring here a back cross, which we call Orubugo. So, I have never seen you in a back cross. I think we should not accept that, right, Honorable Speaker.
Asuman, Honorable Asuman, go back where you're sitting. Go back. Go back.
Madam Speaker.
Yes, Honorable.
Madam Speaker, we have seen members walk into this house just because of the African wear or traditional wear.
Like
Some of them walk into this house with blouses. That's because it is traditional wear. Madam Speaker, I want to implore our members that the chairman of the committee has done a commendable job. And these people want to hide, putting on, is it kaunda, is it what? That must be banned. Let me conclude. No. Madam Speaker, just like the chairman said, order, you will be thrown out.
Anifa.
Just like the chairman said, we must inspire people out there who are watching us. Before I came to this parliament, I used to watch the likes of Abudu Katuntu, the likes of Okupa, the likes of Okule Park, the likes of what, how they dress. I started dressing like that. Madam Speaker, we must inspire people who are out there. If you don't want to put on a suit like this, you go back to Toroma wear. But we must put on suits.
Madam Speaker,
Yes. Can you withdraw the word Toroma? Ebwalu.
Madam Speaker.
Ebwalu, withdraw the word Toroma. That's a
Madam
personal
Speaker,
attack.
Madam Speaker, I withdraw. If I don't want to put on a suit, let me go back to Soroti. I withdraw.
Okay.
Thank you very much. I withdraw, Toroma.
Madam Speaker, first of all, colleagues, I want to thank my brother, Honorable Rone, for raising an issue on African wear. We can all go back to our wardrobes, and I want to confirm, I speaking has quite a number of African wears. And I want to say the following as I debate on this subject matter. First, I support the proposal by the committee. Friends, we must be sincere to ourselves. This is the National Assembly of the Republic of Uganda. It is even wrong for us to begin comparing African wear to the UPDF uniform. Please, the UPDF is our national army, and they also have a designated uniform for these specific functions, like the way General has just stated it here. So for us to come here and begin imputing and trying to compare an African wear with a back cloth. Friends, Madam Speaker, with due respect, I always admire the LOP. The LOP has never come here in an African wear, but I like him whenever he's out there, he's on African wear doing his normal duties. So can we take our African wares for our constituency work to continue being African? But for purposes of this National Assembly, I want to implore us.
Honorable members, can we have some silence? Can we have some silence? I want to hear from Honorable Goli.
Thank you very much, Honorable Chair. Colleagues, the catchword which we have is decent and smart. I want to mention that around the world, clothing is a very big item in development. And to support development, especially the youth, we need to have tailoring promoted, which can be used to promote this country. No, even you see the Nigerian clothing, which is there. It was purposefully promoted. If you wear a decent African wear, which is well tailored, you are going to promote others to wear it.
Mariam.
Thank you. Thank you, Madam Chair.
Yes.
Madam Chair, I want to commend the committee. Madam Chair, we need to appreciate we are all Africans, but members have taken it out of order. People are now picking materials from Owino, they take to any tailor and he makes any form of cloth. Then he appears here that this is a traditional wear. Right, Honorable Chair, when you make a Honorable Macho stand up, right, Honorable Chair, in just this house where we are, Honorable Macho is in a traditional wear, Honorable is a but you can't compare the two. So avoid measuring which one is viable and which one is not viable. We phase it out. We can promote the tailors of traditional wear in other activities, in our constituencies, when we are doing other activities. Thank you, Right Honorable Speaker.
Thank you. Honorable Mujira, can you tell us which uniform you're going, we should gazette for you?
Thank you. Thank you very much, the Right Honorable Speaker and
Honorable
colleagues.
members, can we listen? Can we listen?
The institution we represent is a disciplined, rule-based, and order-based. So we are very happy that the committee has come up with these proposals to amend these rules so that there is decency in the house, there is order, and we don't have anarchy. That's point number one. Number two, on the question of uniform. A uniform is a symbol of honor. It is a symbol of pride. It brings discipline, which is the bedrock of any organization, especially the military organization, and for which we are known. It is a symbol of identity for purposes of identification. Otherwise, we can be mistaken to be militias. So, for purposes of discipline, for purposes of identification, we need to put on this uniform. Thirdly, as has been pointed out, this one, our presence here, is a creation of the law, of the Constitution of the Republic of Uganda.
Thank you.
How else can you identify us? I therefore wish to associate myself with the recommendations of the committee that we put on this uniform, but we are discouraged from putting on the combat, and we are going to sort it out as a caucus, as UPDF. Thank you very much for the opportunity.
Honorable members, we are talking about the decency of members of parliament, and when you look outside there, somebody will say, I wish I could dress like that, like Silo. And these are some of the things that encourage children or people outside there. And I mean, it should also be, as he has said, rule-based. And it is our pride. How it looks so beautiful. Listen, honorable members. Honorable members. Honorable members. Honorable members. Honorable members, when we pass the rules, Honorable Masiko will not come with that madoa. When we pass the rules, thank you. Honorable members, I want you to listen to me. Honorable members, I am thinking that whatever the committee did was in good faith. It was for the pride of this institution, for the good image of this institution. It is for the betterment of this country that when you go to Ugandan parliament, the decency in the Ugandan parliament, and I am telling you, Honorable Macho, much as you're my friend, I will not allow that. Honorable Macho, we will not allow that. You get it, eh? Listen, honorable members, we have agreed a council with a trouser inside with a coat. Are we together? We've agreed a gomasi. We've agreed the official attire of the police. Okay? We have agreed hijab for the sake of the Muslim fraternity. I want to hear from you. Let me first hear from...
Thank you very much, Right Honourable Speaker.
Let me hear from Bulambuli first. From Munibi, then you.
Yeah, thank you. Thank
Honorable
you,
Mudimi.
thank you, Madam Chair. Madam Chair, really what we are trying to discuss, members, I'm submitting. I've seen on several occasions.
Honourable members, can we listen?
I've seen on several occasions.
Honourable members. Dr. Bed.
Madam Chair and the members, I've seen colleagues at times in committees come in T-shirts, attending committee work. T-shirts and open shoes. So we have been talking about jackets, swords. We also need to talk about shoes. Which type of shoes should members of parliament should put on? I've seen colleagues come with open shoes, in a T-shirt, in a jeans, all that. So at one point, members, at one point, we had invited...
Honorable Mudimi, the rules apply both to the committee and the House.
Yes. So we should agree on which type of shoes should we put
In
on.
the circumstance where, say, somebody has a wound or whichever, he will seek leave of a speaker to say, I will be putting on open shoes. And I made a mistake when I mentioned the uniform for police. It is the uniform for our army, UPDF. And when you look at 2, it talks, 82.2 talks about the shoes. Yes, Attorney General?
Right Honourable Speaker. Right Honourable Speaker, I wanted to propose an amendment to 82.2B. Right Honourable Speaker and colleagues, I want to propose an amendment to 82.2B, which would be by substituting for paragraph 3 the following: decent blouse with sleeves, decent skirt or decent trousers, or decent blouse with a jacket, and decent skirt or decent trouser. I want to add closed shoes. Yes. I remember a colleague who came here in sandals some time back. Yes, so I want to propose that we add
82.2.
Does it cause any harm?
82.2.
I want to closed shoes for men, dignified shoes for women.
Right, Honorable. We have also seen situations where some people put on very rare colors of stockings, which are not acceptable. Yes, I've seen it, yes. Somebody comes with a color which is totally not acceptable. So if we're really working on our rules, let's do it once and for all. We have seen those situations. You put on a yellow pair of stockings.
Thank you.
Red.
Atiang, Atiang.
Let me take the information.
Atiang.
Thank you. Thank you. Thank you, Right Honorable Speaker. I just want some clarification. Order. I just want some Protect me, Honorable Speaker.
Honorable.
Protect me, Honorable Speaker.
Atiang.
Yes, thank you, Honorable Speaker. I just want some clarification. Looking at the list that the DAC has just given, I've not seen any clarification on the dresses, especially the dresses, the kitenge dresses, because we also have decent kitenge dresses. Yes, I can, kitenge dresses. So I need clarification of that. And then the other one is, a moment. And then the other one is on the issue of traditional wear. A moment.
Thank you, Madam Chair. Thank you, Madam Chair.
Bugabula, I'm still, Atiang is still. Honorable Asinansi, you actually dressed indecently. So you cannot even speak.
Chair, I want to comment on the issue of avoidance of the traditional wears and acceptance of a few traditional wears like the gomasi and the kanso. Yet we are denying other traditional wears like sukas for the Banyankole, like the skirts of the Karamojong. So I would request that we avoid double standards. If we are saying we don't want traditional wears, let it be across all board that we don't accept any traditional wear in this house. Why Gomez only and why council only?
Thank you, Madam Chair. Madam Chair.
Honorable members, we are going to finish all the time on this. We have an agreed position. And the agreed position, amendments have been made. I put a question that the proposed honorable members, I put a question that Rule 82 be amended as proposed with its amendments. Those in favor say on the contrary, nay. The ayes have it.
New rule.
Honorable members, I remember of recent, Honorable Wetangula chased away a counter suit, a safari suit. And even the president of Kenya, when he's going to the house, he changes and goes in a suit. Let's not make this house dress like we are going for burials. Next.
Thank you very much, Madam Chair.
Next.
Madam Chair, I feel like going to another rule.
Next rule?
Of gross disorderly conduct.
Yes.
Okay, maybe let me start
New
with
rule.
another one.
New rule?
The rules amended by inserting immediately before Rule 85 the following. Sanctions.
Sanctions. After
85A.
85A.
Yes. Where the Speaker or the House finds that a member has breached the code of conduct or that a member has breached any of the provisions of the rule has been provided, the Speaker or the House may, in addition to any other sanction to which a member may be liable under these rules, A, issue a formal warning to the member, B, reprimand the member, C, direct the member to apologize to the House or any other person in a manner determined by the Speaker or the House, D, withhold for a specific period of time the member's right to use or enjoy any specific facility provided to members of Parliament, C, remove or suspend the member from any other position held by the member in Parliament for which no specific grounds for removal or suspension are provided under these rules or any other law. F, suspend the member from the service of the House or any committee for a period determined by the Speaker or the House. Justification, to provide for sanctions, breach of the conduct of the Code of Conduct and breach of the rules where no specific sanction has been provided.
Aisha,
I agree with the majority position.
I put a question that the proposed new clause be inserted as proposed. Those in favor say, and the contrary nay. The ayes have it.
Insertion of new rule.
Rule 88.
88.
Rule 88, this is the proposal, be amended by inserting immediately after sub-rule 2 the following. 1, gross disorderly conduct. A member commits an act of gross disorderly conduct if the member, 1, defies a ruling or direction of the Speaker or chairperson. 2, disrupts the Speaker's communication. 3, demonstrates or makes disruptive utterances. 4, declines to retract words ruled unparliamentary by a presiding officer or declines to offer an apology when ordered to do so. 5, attempts to or causes disorder of whatever nature. 6, uses or attempts to use violence against any other person in the House, committee, or within the precincts of Parliament. 7, destroys property in the House or committee. 8, attempts to or disrupts the Speaker's procession. 9, attempts to or removes the mess from its place. 10, deliberately gives false information to the House. 11, publishes or discloses a committee report, evidence, or a document received by a committee before the presentation of a committee report. Justification, to provide for circumstances under which a member's conduct may amount to grossly disorderly conduct as referred to in Rule 82. 2, to enable members to rise on a point of order where a member commits an act of gross disorderly conduct. I beg to move.
Aisha.
There was consensus.
JJ.
Right Honourable Speaker, I'm in agreement with most of it, except I wish to add one word on 11. Publishes or discloses a committee report, evidence, or a document received by a committee before the presentation of the committee report to Parliament. Because the presumption is
yes,
they are public documents, but they only become public after presentation.
Yes.
You don't have to let by concede.
Clarification, Chair?
I put a question that Rule 88 be amended as proposed and amended by the Attorney General. Those in favor say on the contrary nay. The ayes have it. Honorable members.
Rule 90.
Honorable Silo, we have been sitting here from 2. You're in church, eh? Okay. Yes.
Madam Chair.
The rule has passed.
Rule 90.
The rule has passed on
Substitution of Rule 90. A member suspended to withdraw from precincts. Rule 90 is substituted for the following. 90A. A member who is ordered to withdraw or who is suspended from the services of the House or committee under these rules shall immediately withdraw from the precincts of Parliament and shall not participate in any parliamentary business or activity until the end of the suspension period. Justification. To ensure that members do not participate in parliamentary business or activities for the period of their suspension.
Aisha,
There was consensus.
I put a question that Rule 90 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Rule 91.
Madam Speaker, Madam Chair, the committee proposes that Rule 91 is amended by substituting for Sub-Rule 1 the following. Defamatory statement to be investigated by the Committee on Rules, Privileges and Discipline. 1. Whenever, in the opinion of the Speaker, a statement made by a member is prima facie defamatory of a member, the Speaker shall refer the matter to the Committee on Rules, Privilege and Discipline for inquiry. 2. By inserting immediately after Sub-Rule 1 the following. Where a member makes a statement in a committee which is prima facie defamatory by a member, the chairperson of the committee shall refer the matter to the Speaker. 1B, where in the opinion of the Speaker, the statement referred to under Sub-Rule 1A is prima facie defamatory of a member, the Speaker shall refer the matter to the Committee on Rules, Privileges and Discipline for inquiry. 1C, notwithstanding Sub-Rule 1B, where a defamatory statement is made before the Committee on Rules, Privileges and Discipline, the Speaker shall refer the matter for inquiry to a select committee appointed in accordance with Rule 190. 1D, where a matter is referred to the committee under Sub-Rule 1 and 1B or 1C, the committee shall report its findings to the House not later than 21 working days after the matter is referred to it. Justification. To reconcile with Rule 175, which requires the Committee on Rules, Privileges and Discipline to consider matters of discipline referred to it by the House or the Speaker. 2. To allow the Speaker retain the powers of referral of business to the committees. 3. To provide for referral to a select committee where a defamatory statement is made before the Committee on Rules, Privilege and Discipline, because it will be a conflict of interest if the same committee hears a matter that is arising during its business.
Let me first hear from Aisha.
No, this is a suit, by the way. But if the rules are going to remove it, at least I'm always smart. Madam Chair, I want to learn from the chairperson of the committee, where does the defamatory statement occur? Recently, we had challenges here where people abuse themselves within the constituency. Others were fighting in Irengo. Now, if it's outside premises of Parliament, shall we take that as a defamatory statement against the member, or it is within the premises of Parliament? Because we don't want to go into work of court outside the Parliament. And the business of the Speaker in protection of our members is within the premises of Parliament. And the Attorney General should come out clear on that. Where do we see defamatory statements? Here in the premises of Parliament or out? Members are going to start abusing themselves outside, depending on where they come from. Chiruhura, a member from East Chiruhura, West Chiruhura, a woman MP are attacking each other. These are examples. They have not done it, senior man. But we want to know that, Madam Chair. Otherwise, we need to insulate that area very carefully. Thank you.
Right Honorable, free speech is very, very critical in democratic societies. And Parliament should be allowed to allow members to deliver freely. I have a feeling that if we over-legislate on this matter, members will end up coiling up and they fail to debate. In my opinion, it will be good for us to allow members, if we talk of defamatory statements, for instance, what qualifies to be defamatory? Can we standardize it? Can we specify? Can we describe properly so that there is a measure? Even before I enter the precincts, before I enter the house, I start practicing to speak without getting caught up. So, no, because when you talk about committee, how do we know that everybody is being treated fairly? Let's not overlook ourselves to the extent that we'll even fail to debate. I would try to, yeah. We should move freely.
Honorable members, when you look at the rules, Rule 91, whenever it is in the opinion of the Speaker or a person presiding the committee, Dr. Nekesa, Silo, yeah. Honorable members, 91.1, whenever the opinion of the Speaker or a person presiding the committee, a statement made by the member is prima facie defamatory of any person, the person presiding shall refer the member for inquiry to the Committee of Rules, Privileges and Discipline, which shall report its findings to the House not later than 21 days. It is confined to the House and the committee. Yes. But that does not give you the latitude to go and abuse a member in his constituency.
Right, Honourable Speaker, I agree with this proposal. But Honourable Chair and the Chair of the committee, I would like us to put a provision or create room for a party who considers himself culpable, put room for a party who considers himself culpable before the committee, admits, and the matter ends there, and the committee does not have to report back to the House. For example, Right Honourable Speaker, I keep joking with Kabanda, assuming I call him a Mnyamulenge today, and the Speaker deems that defamatory and refers it to the committee. If I go to the committee and I admit and apologize, does the committee, and I withdraw, does that committee have to bring that back to the House with a report?
Can I give you the case of Kagabo? Kagabo went to the committee, admitted, and apologized. The committee came back to the House with a report, with apology of Kagabo, and the House forgave Kagabo. Because that was a report, it was a House referring. So the House was to receive the report, and that was where it ended. Yes.
Chair wanted clarification from the chair of the committee about defamatory statements made on social media, because there's a case law now. The defamatory statements were on Twitter or the other social media platforms. So if I pronounce defamatory statements against a member on Twitter, on Facebook, how does the rule help with that?
The civil court can apply on that. It will apply on that.
Right Honourable Speaker, the Attorney General here has just gone on record calling me a Mnyamulenge. A Mnyamulenge, Right Honourable Speaker, is a member of M23.
Are you sure?
Yes. I am requesting that the Attorney General withdraws that statement, because the government of Congo can start looking for me thinking that a member of M23 is a representative in the Ugandan parliament.
Actually, I didn't hear the word Nyamulenge.
Because he's part of them.
So as you can see, he's okay. I withdraw mine.
Thank you. Yes, Honorable Baka.
Thanks very much, Chair. I've been listening, and I want to thank the chairperson of the rules. You know, we have intended to be excited by giving the powers of the Speaker to the committee chairpersons. Madam Speaker, we have experience whereby when we are conducting our businesses, particularly committees on accountability, you find a chairperson almost being biased with the people who have come to be interrogated. And the members get annoyed by saying, please give us chance to question them. Now you are extending the powers of the Speaker by saying, there the chair can say, I have sacked you, and you will also miss plenary. I think we need to be very careful when we are trading on that. I don't know if I misunderstood the statement.
It is for the Speaker, not the chairperson of the committee. Yes. Honorable Baka, it is for the Speaker.
Madam Chair, we have had these scenarios in the committees of parliament, and some members were with us in the park. Remember, a member of parliament comes and makes a formal statement against a fellow member that this person got 10 million, 30 million from this entity we are facing with. He even got this and that. Then the chair says, honorable member, he says, I have evidence. I have everything. The chair says, please produce the evidence. The member says, stop intimidating me. And it becomes another stalemate in the committee. So where there's defamation in the committees, me I am very in acceptance of the powers of the chair. And whenever chair is chairing a committee of parliament, it is the Speaker chairing that committee.
Honorable members, let me read you 89.2, where a member has been named. Then, in the case of the House, the Speaker shall suspend the member named from the service of the House, or in the case of the committee of the whole House, the chairperson shall forthwith, with the leave, the chairperson will report the circumstances to the House, and to the Speaker shall suspend the member named from the service of the House. We've had scenarios from accountability committees where their members have behaved in a funny way, and the chairpersons have reported those issues. And we've handled them administratively, either transfer you from one committee to the other or whichever. So the powers are not yet with the chairpersons. Then, where a member has been named by a chairperson of the committee, the chairperson shall, with the consent of the committee, suspend the member named from its service and report the next sitting of the House. With the consent of the committee, not as a person, and then report to the House in the next sitting. Yes, Butiru.
Thank you, Right Honorable Chair. I want now to put it vice versa. Here you are talking about a member who is behaving in a funny way. Now, in the event that the chairperson is the one behaving in a funny way, what happens to that chairperson? Can now the committee now suspend the chairperson? Because now that one also needs to be spelled. Thank you, Chair.
Honorable Member, removal of a chair or a deputy chairperson from office. That is the procedure. Rule 195. A chairperson or deputy chairperson of a committee may be removed by members of the committee on a motion supported by 2/3 of all members in the committee on any day of the following grounds: 1, incompetence; 2, misconduct and misbehavior; 3, failure or refusal without justification, reason to execute the duties of the committee. Okay? The powers are in your hands. And where you are in a committee and a chairperson alone says, I must put this person to oath, and members have not agreed, you put it to vote. Members must agree that this person must go to oath. Chair. On which one? On which rule? Wait and they read the rule. No,
Yeah,
we have not reached
it's
there.
not part of the
I was
report.
only just clarifying what Butiro was saying. 88. '91, where there was an addition of Parliament.
Somebody messed up my papers. That's page what? Okay, ma? Page 47. On the amendment. Beg your pardon. Rule 91. I think we're done with Rule 91. We're done with the Rule 91, but the question wasn't yet put.
I put a question that the Rule 91 be amended as proposed with amendment from AG. Those in favor say and the contrary nay. Let's have it.
Rule 109.
Thank you very much, Honorable Chairperson. Rule 109 is substituted for the following. Proceedings for censure of a minister shall be initiated by a petition to the President, the Speaker, signed by not less than 1/3 of all members of Parliament. 2, a member who is desirous of moving a petition for the censure of a minister shall notify the clerk in writing of his or her intention to present a petition to the President. The proposed petition shall cite the grounds and set out the particulars of the grounds for censure. 4, the clerk shall, within 3 working days of receipt of the notice of petition for censure, in sub-rule 2, notify the Speaker of the proposed petition. 5, the clerk shall, within 3 working days after notifying the Speaker of the proposed petition, notify all members of Parliament by causing the proposed petition to be pinned on the members' notice board and uploaded on the Parliamentary Information System. 6, the clerk shall, on the date of pinning and uploading the proposed petition as required, in sub-rule 5, cause to be prepared a list of all members of Parliament with an open space against each name for the purposes of appending signatures, which list shall be titled Signatures in Support of the Petition for the Censure of the Honorable blah blah, Minister of blah blah in the Republic of Uganda. 7, the list of members of Parliament in sub-rule 6 shall be deposited with the Sergeant at Arms for a period of 10 working days for purposes of the members of Parliament appending their signature shall not be withdrawn. I repeat, a signature appended under sub-rule 7 shall not be withdrawn. 9, When at least one-third of all members of parliament have appended their signatures on the list signifying support for the proposed petition under sub-rule 1, the sergeant at arms shall immediately forward the list to the clerk, who shall not later than 24 hours transmit the petition to the speaker. 10. If after 10 working days referred to under sub-rule 7, less than one-third of all members of parliament have appended their signatures on the list, the petition shall lapse. 11. On receipt of the petition under sub-rule 9, the speaker shall transmit the petition to the president. 12. The speaker shall, upon transmitting the petition to the president, inform the petition has been submitted to the president. 13. The president shall, upon receipt of the petition, cause a copy of the petition to be given to the minister against whom the motion for resolution of censure is to be moved. 14. The petitioner shall, upon receipt of the information from the speaker that the petition has been transmitted to the president under sub-rule 12, notify the clerk that he or she intends to move a motion for resolution of censure of a minister. 15. The motion shall set out the particulars and grounds of the vote of censure against the minister. The speaker shall, under 16, after 14 working days of receipt of the censure motion, cause the motion to be placed on the order paper. 17. The petitioner shall move the censure motion and lay all supporting documents on table, and each document so laid shall be endorsed by the clerk. 18. The speaker shall refer the motion and all supporting documents to a select committee appointed in accordance with Rule 190. 19. The select committee to which the motion is referred to under sub-rule 18 shall examine, analyze, and scrutinize evidence adduced in the matter and report to the House after 15 working days. 20. The committee may, in exercise of its duty under sub-rule 19, co-opt any person to the committee. B. Receive additional information. 21. The committee shall give a minister against whom a motion for resolution of censure has been moved, his or her representative an opportunity to appear before the committee to defend himself or herself against any allegations made. 22. The motion for the resolution of censure shall not be debated in the House until the expiry of 30 days after the petition was transmitted to the President. 23. Upon presentation of the Select Committee report, the Speaker shall: A. Where the Select Committee finds that evidence adduced supports the grounds for the vote of censure, call upon the petitioner to open the debate on the motion, followed by the minister against whom the vote of censure has been moved to provide his or her defense before the debate ensues. B. Where the Select Committee finds that the evidence adduced does not support the grounds for the vote of censure, or that the allegations are false, misleading, frivolous, the Speaker shall put a question for the adoption of the report of the Select Committee. 24. Where the question for the adoption of the Select Committee report is carried under sub-rule 23B, the motion lapses. Where the question for adoption of the Select report is not carried under sub-rule 23B, debate shall ensue. 26. After debate in sub-rule 23A or sub-rule 25, the House shall vote on the motion for the resolution of censure, and if the motion is carried by more than half of all voting members of Parliament, the minister is censured. 27. The Speaker shall, within 24 hours from the time of censure of the minister, inform the President of the censure of the minister, and the President shall take appropriate action in the matter. Justification: to align the procedure in the rules with the provisions of Article 118 of the Constitution on the censure of a minister. I beg to move.
Thank you. Thank you. Honorable Katuntu, I want you to look at Article 118. 118 and relate with what you're giving us. Relate with part 1. Article 118. Where you're saying proceeding for censure of a minister shall be initiated by petition to the President through the Speaker signed by not less than 1/3 of the members of Parliament. Doesn't it contradict with the Article 118? 1183. Yes? 1183.
What we are trying to do here is to align our rules with Article 118.
Yes.
Thanks very much.
Yes.
Thanks very much, Madam Chair. Madam Chair, I've just heard that when I've put my signature on the censure motion, I'm not supposed to withdraw the signature. I want to ask the wisdom of the Attorney General, isn't that my constitutional right? About if I've been coerced with wrong evidence, and the following day I found that what you convinced me was wrong, can't I withdraw my signature? No, I want to be guided by the Attorney General. Yes. Madam, I want to be guided.
Attorney General?
Right Honourable Speaker, I need protection. There's a lot of
Members, Jessica.
Right Honourable Speaker, Honourable Katuntu and the other lawyers in here know very well that a judge sits and writes judgment, but he can be persuaded to review his position. There are exceptions. You could sign in support of a censure motion, and yet you were not privy to certain information. And then you get information or evidence to the contrary. So freedom of conscience, and whatever happens, no one has a right to take away your conscience. So by restricting ourselves in this proposal, we are curtailing your freedom to withdraw, even when you discover evidence to the contrary. I would want to qualify it, Honorable. I would want us to qualify it and say within a particular period, your signature cannot be withdrawn. We qualify it by providing for, let's say, 7 days. I beg to submit.
Yes, Aisha.
Thank you.
By the way, when you read 118 in totality, you find the committee is right.
Thank you. Thank you, Right Honorable Chair. Members got excited, began debating before I gave the position of the minority. Right Honorable Chair, what the majority committee did was to align our rules with the Constitution, and I entirely agree with what they did, but have an amendment, an addition. The proposed rule 109 is amended by inserting immediately after subparagraph 27 the following. 28. Where the President has been informed of the censure under sub-rule 27 and has not yet taken appropriate action in the matter, the Speaker shall, A, where the censured minister is an ex-officio member, suspend the minister from the House in accordance with Rule 90. B, where the censured minister is a member of Parliament, bar him or her from taking up a seat on the front row on the right-hand side of the Speaker. until the President communicates his decision on the matter. Justification is to ensure that the censured minister only resumes his duty in Parliament after the President has taken appropriate action following the censure. Thank you.
Madam Chair, I think let's have this clarification. First of all, unlike the practice in some of the committees, I would like to thank the Honorable Aisha Kavan. All her points of disagreement, she brought them in the committee and we discussed them in detail. All of them. So there is no view she's giving where she's ambushing us as a committee. We had the opportunity to discuss whatever she has, and we didn't agree, which is normal not to agree. You see, there is always a mischief. What was the mischief here? Historically in this house, for those of you, especially those who have been in this house longer than me, you would know that during no, we are talking about a different thing, Honorable Chibalia. You see, there is a petition which is initiated. Immediately it comes out, members are unduly influenced. Then they go withdrawing their signatures. Yet they have already made the petition to believe that he has even got enough signatures. So when they are unduly influenced and they withdraw the signature, the petition does not see the light of the day, it just collapses. Now, there is an opportunity for a member, I think Honorable Baka and Honorable Attorney General, the ones they are talking about. This is just the beginning of the process. But at the time of voting for that motion, you have a right to change your mind and say, when I signed that petition, I was not privy to this information. Now I have it, and therefore I will not vote for this transparently. Other than going, you withdraw, you append a signature, then you go there and say, I've withdrawn. You just cause confusion.
I'm giving information. Madam Chair, more information to the Chair of the Rules. Madam Chair and other members, once a petition of this nature is brought, it's about convincing members on both sides. And let me tell you one interesting scenario we've had here. Members who have been on Ogwang, we came together on a minister. Even, you get room to hold your members off before they sign anything, recall of parliament or anything. One time we had the recall of parliament, and the members could hide their members. You look for them, you don't get them. You go up to Kweni looking for a member to sign. So by the time you sign, the one who is, if I'm trying to convince you, someone else is coercing you not to do, sign. So you can even be coerced to withdraw. The best option is what the chair has given. They just sit, because at the time of voting, but you cannot be a member of parliament who signs a document. Then you say, I was misled by Tom or Peter at the initial stage. They were a member of parliament. That's why musicians like Warukagav sang songs against us about a member voting in the parliament and their votes which have been invalid in the house. It's very funny.
Yeah, thank you, Right Honorable Speaker. I think what Honorable Seungu is raising is totally different. Here we have an example on the service awards. I came and gave those people who are collecting signatures, my signature, on the commissioners, just on one item, service awards. When they collected all the signatures, they went and amended the motion. They added on some other things, trips, jobs, and many others. Now, if you amend a motion, yet I gave you my signature on something different, why should you stop me from coming to withdraw my signature?
Thank you. Right Honorable Chair, from the independents, this is the independent voice. Right Honorable Chair, even in the banks when we deposit money, we withdraw. Yes, even in the banks when we deposit money, we withdraw. Sometimes we say fixed account, savings account, current account, things are there. Even in the marriages, there are divorces, people divorce. I think it is very, very important. At our level, we are people who have full conscience to determine what is right in our own judgment. So we should be freely thinking about what is right and what is wrong. But not to lock it and say, if you sign, you cannot withdraw. I have seen people about journeys. I wanted to travel, I've stopped, I've stayed. So all these things happen. So, right Honorable Speaker, at least I know through your wise guidance, this House will not make mistakes. Through your wise guidance. Thank you.
Thank you.
Madam Chair, Chair, we have been debating since morning to say that this is Parliament. Madam Chair, by the time a member of Parliament appends a signature, he has really thought very many times about the motion. How do you go to sign and now tomorrow you receive a call and you withdraw? This can't be, madam. This is Parliament. This is not sitting for councillors.
Honorable members.
Madam Chair, as I conclude, the Honorable talked about the motion. Madam, I want to be helped by the chair. A motion, according to what he was reading, must be presented here, and the signatures are in the Sergeant Arms office. Where is the scenario where people looking for signatures come to Jinja, go to the radio, and say, Chibalia, we are looking for you. You come to Town Hall and sign. Where have you catered for that part?
Where have I catered for that scenario? I have not catered for it because I don't think it's correct.
Madam Chair, Madam Chair.
Honorable Minister, before the chair says it's not correct, it happened. The motion that has been here moving everywhere, people came up country.
Madam Chair, colleagues, Honorable Katuntu, I have a lot of respect for you, and I will continue to have that. But I want to say the following. For God's sake, why do we want to believe as if we can't change our minds? Let's be realistic. You see, sometimes we stand here and we begin to think as if we were angels, we can't make mistakes, we are normal human beings. So for purposes of a signature, if I've appended my signature based on certain information, and I'm convinced to change my mind, why shouldn't I withdraw my signature? For God's sake, why should it become criminal that for me it should be permanent? No. We are here to legislate. Friends, we are here to make rules for the governance of this house. I want to propose that let's have rules of procedure where a member is free to withdraw his or her signature. I thank you.
Chair, if I could give
Honorable members, the amendment of May should now apply on 107. One 108, 109, and 110. If you are agreeing that a member may withdraw, let it be uniform across the board.
It should include the petition for the removal of a speaker. Should also include the petition for the removal of a speaker. Censure of a speaker.
I agree.
Yes.
If
So it
it's
cuts across.
applying across the board,
Yes.
I have no objection.
It should apply across.
I have no objection. Members should treasure their signatures. Members should stress their signatures. And their signatures should be not be available for buying.
Honorable members.
Right, Honorable.
Yes.
I want us to be clear.
You make a clarification.
I want us to
Attorney
be
General.
clear. Right, Honorable Speaker, I want us to be clear. This issue arose after the proposal was a signature appended under sub-rule 7 shall not be withdrawn. And we started creating exceptions. We said there could be new evidence that you were not privy to before a signature. Secondly, as a member of parliament or any other human being, you have freedom of conscience. You can change your mind. You do not even need to be influenced. They can allege that you have been corrupted. That is very okay. What matters is your conscience. People have been nominated to contest in primaries as NRM. The next day, they stand as independents. They withdraw. So let us not tie our hands here. But what we have to do, right, Honorable Speaker, is to make sure that this proviso is extended to the proviso on the censure of a speaker.
No, the president, the speaker, the minister, the commissioners.
All the other censures provided for, one should be at liberty to give or to withdraw one's signature. I beg to submit.
Thank you so much, Right Honorable Chair. Right Honorable Chair, colleagues are perceiving this as if a signature on a censure motion tantamounts to a vote for censure. A signature for censure motion
It is a
to go through a
precursor.
process
It is a precursor.
to give you an opportunity to discuss even circumstances, even to give the minister opportunity to come and make his case. So you having signed and new issues come up, actually it's an opportunity for those issues to be relayed here in the House. So people should not fear that once you sign a censure motion, you have signed. No, you are just beginning a process. And the reason why the members should know that that rule is not an input of our committee. It has been an existing rule. It has just been planted and put in the right position where it belongs, just to enable process to take place. Otherwise, Right Honorable Chair, if people are going to go start signing and removing, no censure process will never start here in the House.
Honorable members, the signing of a censure motion is a precursor to the removal. It is not final. But you cannot have a may for a minister, you have a shall for a commissioner, you have a shall for a speaker, deputy speaker, you have a shall for the president. No, not to committees of parliament. We are now talking about the big people, not reports. So we are saying the may will cut across from 107 to 110. I am putting a question that Rule 109 be amended
Madam
as
Chair,
proposed with amendment on May, cutting from 107 to 110. Those in favor say on the contrary, nay. The ayes have it.
Rule 110.
As amended, yes.
The
Yes.
Chair.
Chair, it's not on record as amended by both the minority and majority because we had two. Yes, I put my amendment also. I said I agreed entirely with the committee and I made additional suggestions. So it's as amended by both the majority and the minority reports.
Attorney General.
I think the Honorable Kabanda makes a substantive amendment in addition to the general one. And if members carry or vote for it without appreciating it, might be very difficult to justify. I would request that the Honorable Aisha Kabanda puts that specific amendment so that the members know exactly what they are voting for.
Let's first finish what is coming from.
Madam Chair. Madam Chair.
Right, Honorable Chair. Am I on? The proposal is to add addition to where the chairman ended. Say where the president has been informed of a censure under subparagraph 27 and has not yet taken appropriate action in the matter, the speaker shall A, where the censured minister is an ex officio, suspend the minister from the House in accordance with Rule 90. And B, where the censured minister is a member of parliament, bar him or her from taking up a seat on the front row on the right-hand side of the speaker, until the president communicates his decision on the matter. So the justification is to ensure that the censured minister resumes their duties in parliament after the president has taken appropriate action following the censure. Right, honorable colleagues, the Constitution says the president will communicate. But there are cases where the president does not communicate. And in my opinion, we cannot deem the president's silence to be communication, whether for or against. So this proposes, because in our rules in Rule 90, any member of parliament can be suspended. So this proposes that a censured minister is subjected to Rule 90 until we hear from the president. And the effect of the Rule 90 would be that an ex officio is barred from attendancy, whereas a member of parliament is barred from sitting on the front row until we hear from the president. Otherwise, we can't simply sit and the president becomes incommunicado and parliament does its things as if business is normal. I submit.
Chair, Madam Chair, as the amendment brought by Honorable Aisha, I'm seeking clarification from Madam Aisha, because she said when the minister is a member of parliament, is barred from sitting on the front bench. But does he continue executing the duties as a minister, or equally those duties are stopped until the communication from the president has come? And lastly, Madam Chair, the provision that has been suggested by the chair of the committee that before we begin appending our signatures, you write to the president. How do you first write to the president to give us permission to append the signatures on essential motion? It means our powers are gone now. The president will not allow, because according to the report,
you know that is a constitutional provision. If you want 1183, if you want, you can have an amendment of the Constitution, so that you have all your powers.
Chair, let the president have action after us appending and passing the motion. But first seeking permission from the president, Madam Chair, we have surrendered our powers to the president and we shall never have the essential motion.
Colleagues. Yes, Chair. Just a moment. Chair, I'm thinking about this from this perspective. Yes, we can bar the minister from sitting on the front bench and also the ex-officio from attending. But what if members of parliament in the House have critical issues that we require answers or clarification from this minister, and now they're sitting behind, we have barred them, they are not even accessing, and yet they're still holding the docket? Where shall we go?
Madam Chair.
Honorable members, the appointing authority lies on the president. And if the president feels or deems it fit that our censure was, I don't want to say no consequence, but was not pleasing him, let it be so. It is, for me, if you have been censured, you can't present a report when I'm chairing. No. You get it, eh? You can sit wherever. But me, I don't recognize you. Period.
Chair,
so
what
we
I
cannot
intended
put it in the rules, because we shall be contradicting with the presidential what? Because we are not the ones who appoint. We don't appoint.
Chair, what we intended to cure, the Constitution 1182, upon a vote of censure being passed against a minister, the president shall, by the word is shall, unless the minister resigns his or her office, take appropriate action in a matter. So this article commands the president to act, okay? But there are cases...
and action, even silence can be an action.
Chair, there have been situations when the president has not acted at all, and yet the Constitution says the president shall. So what we are wanting to cure in the rules is that once a successful censure motion has been passed here in Parliament, as we wait for the president to communicate, a minister does not behave as a minister in this house. That's all. Unless the president comes back and says, I want my man and my man must stay.
Madam Chair, let us correct the mischief. Madam Chair, and the honorable members through the chair, censuring of a minister, writing to the president everything is a process. There is no way you can stop a minister carrying out his duty and remaining a minister until you come to the final process of censuring him. Because it's in the Constitution, he has what we call the Bill of Rights. You know, he's innocent until proved guilty. So if you attack the Constitution, as you carry out your process, still he can even challenge you in court. So as you censure him, he remains a minister, and it has happened here. So until you conclude the process, you have. Secondly, Madam Chair, writing to the president after giving him the signatures, still the president will refer them back to you. You cannot stop the process because it's getting him as mandated by the Constitution. And your committee was curing a mischief here because the Constitution under Article 118 is very clear, 1183. You must transmit that process at the beginning to the president about his person. You get me? But me, where I have a problem, Madam Chair, is again putting in Rule 190, going to a select committee. That's another tedious exercise we don't need to go through. I don't know why they brought in that area of a select committee to go for the process. Me, I would pray that that area should be pulled out. We take the process as it is. Otherwise, you cannot ask the minister to get off the front bench because you have begun a process. He's still innocent.
Madam Chair.
But of course, if it's at the end, he's essential.
Madam Chair.
Colleagues. Colleagues. First of all, what we are providing in these proposals is not new. That is the current status of our rules as they are now. But what we've done is to transplant the whole process as it is provided for in the Constitution and put them in our rules. Everything we are talking about the Constitution. Number two, the process of censure ends with the president taking appropriate action. The lacuna means the gap. The gap which is there, the Constitution did not define appropriate action. So it left it within the discretion of the president. So
Rule 110.
Yes, until that decision has been taken, this process is still on.
Rule 110.
The only thing we can do, in my view, now that I've listened to it, is say where the present appropriate action shall be communicated to Parliament. Maybe that, because that we can do. We have powers. Because we are not amending the Constitution, but we are trying to align and actually operationalize that particular article. The president's course, course of
action.
Course of action shall be communicated to Parliament so that it is formal. Other than when you communicate and there is nothing coming out of Plot 1 Uganda.
Rule 110. Yes.
Right, Honorable, I appreciate this discourse, and I agree with the chairperson's final comment on that. That should help us put to rest the Honorable Kabanda's proposal. Now, I want to take you back to your proposed amendments. Rule 13. Rule 13, you are saying the president shall, upon receipt of the petition, cause a copy of the petition to be given to the minister against whom the motion for a resolution of censure is moved. Now, natural justice requires that the accused party be served, okay? But Article 94 of the Constitution says Parliament shall make its own rules. But now we are going beyond that and making a rule turning the president into a process server, asking him to be the one to serve the petition upon his minister. You'll guide.
Because you might make an erroneous judgment.
Okay.
What does the Constitution say? Article 114.
The president shall, upon receipt of the petition, cause a copy of it to be given to the minister in question.
My argument is withdrawn.
Much obliged.
Madam Speaker, Madam Chair. Madam Chair.
Yes,
Elder. I have one issue. Basically to support the proposal from Honorable Aisha Kabanda. By the time this House goes through a motion of censure, it will have undergone a very vigorous, very tedious process to reach that decision. Now, the lacuna, what Honorable Katuntu, the chair, said the gap is that sometimes the president's perception of the censure is different from what this House is. And that's sometimes that's why he doesn't take any action. He may not agree with what we are doing here. But this House is convinced that a minister deserves to be censored. So what Honorable Kabanda has said or proposed helps us to be in charge of our decisions here. Let the ex-official stay away. Let the elected member of parliament who's a minister sit somewhere else and do his duties outside there with his president, but not in this House. Quite frankly, yes. Let us exercise our powers. I agree fully with Honorable Aisha Kabanda that the censored minister
should be away, kept away from this house until the president takes action.
Honorable
Thank you.
members, I already made a ruling to that effect. Honorable Mujira.
Thank you, Right Honorable Speaker. I have an issue with the clause 13, and I would wish that it be expunged from this amendment. Clause 13 provides that the President shall, upon receipt of the petition, cause a copy of the petition to be given to the minister against whom the motion for a resolution of censure is to be moved. Why do I have an issue with this? If you look at Article
1183.
I begin with the 94 of the Constitution, which provides for the rules of procedure, which we are amending now. It says, subject to the provisions of this Constitution, Parliament may make rules to regulate its own emphasis, its own procedure, including the procedure of its committees. Not the procedure that is going to be used by the President, which is already provided for under Article 1184, which is very clear, and it says, the President shall, upon receipt of the petition, cause a copy of it to be given to the minister in question. So I do recommend that this be expanded, and we just maintain this provision in the Constitution. Otherwise, we would be putting in place a process for the President.
Honorable Chair, have you heard that the assumption is the minister that we are censuring is not a member of parliament because we are making laws for the house, and the person that we are censuring is in the house, and because the person whom we are censuring is in the house, is appointed by executive. So we as the house must inform the executive that your person you brought to us, take that person back to where you want. I mean, we are copying it from the Constitution. It's a constitutional provision.
Right, Honorable Speaker, you already asked a question over that, and a decision was taken. Besides, there are several laws that we are quoting, transplanting for consistency and coherence and put in our rules. That's not the first one. There are several, but you already asked a question and a decision was made. He can only come on a recommendation.
Next rule.
Thank you very much. See, the Honorable General Mujira, this is just one process. How does it start and how does it end? It starts from Article 1181 and it goes on up to Article 1186. So, to start pulling out some aspects of the constitutional provision, because you see, you need what we call a one-stop center point of law. If you want to know the process of censuring a minister, you go to either Article 118 or you go to the rules of procedure.
Thank you. As you go to
and it's not constitutional in any case. If we are inverting this, that it is just an innovation for our rules without it being in the Constitution, I would agree with you. So
as you go to Rule 110, I want a clarification, a correction from Honorable Kavanda David that on what is said on M23, on Banyamulenge being M23. That may not go well with us, so can you correct that statement of yours?
It is true, Right Honorable Speaker, that not all Banyamulenge are part of the M23.
No, Banyamulenge are not, they are a tribe.
Yeah, I will withdraw, yes, but I need to explain. Because the president of Rwanda and Congo have both agreed that there is a tribe called Banyamulenge and who are Tutsi. So the leader of M23 comes from that tribe, but not everybody that is a Mnyamulenge is part of M23. I withdraw that statement.
Thank you, thank you. Next rule.
Rule 110.
Switch on.
Madam Chair, Rule 110 is amended by 1. In sub-rule 1, Rule 110 is amended